Hello, good afternoon, everyone. My name is Ilgin Yorulmaz. I am the second vice president of the Foreign Correspondents Club of Japan and also co-chair the Diversity Committee. Today, we're going to talk about a very simple question. What is your name? Or rather, what is in a name? It seems this simple question around the world carries a lot of weight in Japan. Because in Japan, when two Japanese citizens get married, one person has to change his or her name, or her last name rather, to the other person's last name so that both have the same surname, according to the Article 750 of the Japanese Civil Code. Now, Japan is said to be unique, maybe the only country in the world, or definitely among the developed nations, where changing of a spouse's last name is mandatory in this fashion. And in 96% of the cases, it's the wife who has to change her name. But for various reasons, many Japanese people across the country would like to keep their names, even if they get married. Some they get married a second time and don't need the hassle to have to change the names in the official accounts or in the bank accounts, passports. Some are professional women, like doctors or academics, who have patents or have published under their maiden names. This leaves people with little choice, and some of them actually have to either change their names or choose de facto marriages, which is the common law marriages, instead of a proper civil marriage. Critics of this separate name movement claim that it will weaken family ties. Well, our two speakers today beg to differ. They actually think this is more of an individual identity, human rights, and freedom issue. We are very pleased to host Naho Ida. She is executive director of an organization called the National Petition Action for Selective Adoption of Surname, which lobbies for the adoption of separate surnames. After experiencing unwanted surname changes not once but twice, in 2018, Ida-san launched the organization with her friends. It lobbies local assemblies for debate, campaigns nationally, and calls for the amendment of this Article 750. And to her right is Makiko Terahara. She is the representative director of the organization Marriage for All Japan. Terahara-san litigates for same-sex marriage and selective marital surnames. After graduating from the New York University School of Law, she worked as an in-house lawyer at Merrill Lynch, Japan, and currently works for Tokyo Omotesando Law and Accounting. She divides her time between her professional work and her advocacy for the rights of women and sexual minorities. And we are very pleased to have also a wonderful interpreter today. Thank you very much. Please, if I may ask Ida-san and Terahara-san just to brief us a little bit about the gist of this matter for those who are unfamiliar, and then we can maybe turn to questions and comments and have it as a conversation. Ida-san, please.
Okay. Thank you for coming. Okay, I'm here today to tell my world my no. No to gender inequality, and no to political discrimination against women. I have changed my last name twice. I did not want to, but I had to because I am a female. In Japanese law, married couple must have the same last name, and nearly all chose their husband's surname. Japan is the last country in the world where a single spousal surname is mandatory. The United Nations has pointed to this situation as gender discrimination and has advised the Japanese government many times to allow couples to use different surnames. However, that discussion on this legal amendment have been shut down in the LDP's closed-door meetings for almost 40 years. The LDP's policy is that women should be satisfied with using their maiden names. But according to a government survey, 60% of those who use their maiden names feel inconvenient or uncomfortable. Even the Justice Minister has officially acknowledged it. Since there is no legal basis for maiden names, people who wish to continue their careers under their maiden names have difficulties in every aspect, such as overseas travels, registrations, patents, and contracts, or even in the hospital. Many young couples have ended up getting divorced to be common law couples because changing their surnames can be quite troublesome and so painful. So I set up an organization in 2018 to lobby calling for amendment of civil code. We have more than 500 members registered nationwide, from teenagers to those in their 80s. Since 2018, we have been holding a number of study sessions for lawmakers from all major parties. Many women testified that they are suffering from the loss of their identity, including female patent engineers, doctors, academics, company presidents, and foster parents, expatriates, bankers, stock leaders, whose track record is difficult to prove because of the name change. In many cases, we have to take a few days off to lose our identity for paperwork. We must bear expenses, and sometimes we even have to apologize. Since last year, my company had started using an electronic signature system. I thought it would be convenient, but only one legal name is allowed. So I can no longer sign contract using Ida, the name I have used my whole career for more than 20 years. Last year, we raised funds through crowdfunding and conduct a survey on the attitude of the people nationwide. In this survey of 7,000 people, we found that 70.6% of the respondents said that they were in favor of a selective surname system. In every prefecture, there were 2 to 10 times more respondents who were open to change than those who were not. I asked legal scholars raise their voices, and 1,094 legal scholars and lawyers signed the petition and met the ministers and all major parties to ask them to amend the law. Ministry of Foreign Affairs documents clearly state that maiden name cannot be used for overseas travel, and it could cause confusion. At the beginning of this year, the Japanese government held a lecture for the embassies, and many embassy staff objected, saying, why the Japanese government tried to force its people to use a name other than their current one? The government staff told me that they didn't understand why. Those companies which hire people using their maiden names also face increasing costs and confusion as they have to manage 2 sets of names for their employees. I invited prominent business leaders calling for an amendment in the law and established a volunteer group. At the Secretariat, I continue to ask people to sign our petition. To date, about 660 leaders have signed in this petition. In particular, many leaders of financial companies who deal with personal identification are supportive. And many of the local assemblies lawmakers too. They have shown their understanding of this problem. To date, more than 300 opinion papers about marriage reform petitions have sent to the Diet. However, 50 members of LDP who opposed to our opinion papers sent letter under the joint signatures to the local assemblies to pressure them not to pass the opinion papers. They include minister and vice minister in charge of gender equality. Ironically, the same politicians who discriminate against women are those who also proclaim womenomics, SDGs, or stimulating ESG investment. In August, a study session was planned with the cooperation of LDP lawmakers in favor of the law amendment to hear testimonies of the trouble caused by the use of maiden names. But again, it was blocked by the opposition lawmakers behind the scene. Satsuki Katayama, a member of the Diet, testified that it was the direction of former Prime Minister Shinzo Abe. Many documents from unidentified senders were distributed in the Diet building, trying to oppress the voices of the people who suffer from name change. And finally, a document signed by Sanae Takaichi, chair of the LDP Policy Research Council, was distributed. I am shocked at the fact that the Diet member would use such cowardly method to shut us up. Isn't it the job for the Diet members to listen to the public opinion? On one hand, forcing married couple to use their same surname, but on the other hand, allowing married women to use their maiden name, which they cannot legally use anyway. Under the banner of promoting women's participation is a clear discrimination against the women's right to choose their names. In the next lower house election, candidates who discriminate against women and sexual minorities should not be sent to the Diet. An anti-abortion law is known for its motto, "My body, my choice." I would like to end my presentation today with my motto, "My name, my choice." Thank you very much.
Thank you, Ida-san. And Terahara-san, if we may hear from you your opinion about this issue. And you are also director of the Marriage for All Japan, litigating for same-sex marriage. So when you're ready.
Okay. Hi, everyone. Thank you for your time today. My name is Terahara, and I am a lawyer. I'm a member of both legal teams for the Selective Marital Surname lawsuit and the same-sex marriage lawsuit. I'd like to give a report on the current status of each lawsuit. First, let me explain the Selective Marital Surname lawsuits.
There's a little technical issue with the screen we're seeing, Terahara-san. So if you may just give us...
Okay. I will continue to speak.
Okay.
We filed lawsuits twice, and the Supreme Court ruled on each case in 2015 and in this June. In both cases, it concluded that the current law that requires couples to have the same marital surname does not infringe on the freedom to marry, nor are they discriminatory. As a main reason, the Supreme Court stated that having the same, having the same surname gives a sense of family unity. The disadvantages of changing one's surname are being mitigated by the widespread use of the maiden name, in fact. Since legal marriage is construed as a package, it is not a violation of the Constitution if a person cannot marry because she or he does not agree with some of its contents. And then the Supreme Court threw the ball to the Diet, saying, the nature of this kind of issue is nothing but a matter to be discussed and judged by the Diet. This is an abandonment of the role of the courts as the last resort of human rights for minorities. But nevertheless, there is no doubt that this issue must be seriously discussed by the Diet. So, what is the attitude of the government? The opposition parties and the Komeito party, which is in a ruling coalition government with the Liberal Democratic Party, have long supported the introduction of the selective marital surname system, but only the Liberal Democratic Party, LDP, continues to oppose it. This year, two groups have been formed within the ruling LDP. One group is calling for the early implementation of the selective marital surname system, and the other group is opposing it and calling for the expansion of the use of the common names instead. Mr. Kishida, the new prime minister, is a member of the group calling for the early implementation of the system, but he has toned down his stance now, saying careful discussion among the public is needed. The Diet members who are opposed stressed that the disadvantages would disappear if the use of common names were expanded. But there is no legal backing for common names. And if legal backing were to be provided, there would be two legal surnames for one person. It is clear that the government agencies, companies, and the society will be confused. In the Supreme Court decisions, some judges pointed out that allowing the use of the maiden name as common name is nothing but acknowledging the irrationality of the current law. Next, I'd like to explain the same-sex marriage lawsuit. In 2019, first time in Japan, we filed lawsuits stating that the current law that does not recognize same-sex marriage violates the Constitution. And the lawsuit is currently underway in 5 locations: Sapporo, Tokyo, Nagoya, Osaka, and Fukuoka. The earliest ruling was made by the Sapporo District Court in this March, which concluded that the current law violates the Constitution, contrary to Article 14, Section 1, which stipulates the principle of equality. As for the main reasons, first, the court set a strict standard for judgment, stating that the reasonableness of a distinction based on sexual orientation, which cannot be changed by one's own will, must be carefully examined from the perspective of whether or not the distinction is truly unavoidable. Then, regarding the purpose and essence of marriage, the court said protection of the common life of the couple itself, with or without children, is also an important purpose of marriage. Even homosexuals can lead a joint life with the essence of marriage. Furthermore, and this is the part that impressed me the most, the court said to say that same-sex couples cannot receive any legal effect of marriage without the understanding or acceptance of heterosexuals is too little protection for homosexuals, even considering that the protection of homosexual couples will bring some changes in the traditional view of family in Japan. As for the attitude of the government in response to the ruling, a chief cabinet secretary maintained a reluctant stance toward same-sex marriage. On the other hand, the Komeito party immediately established a working team to study same-sex marriage, showing a positive attitude. Prime Minister Kishida keeps to say, "I haven't reached the point where I agree." As for the future schedule for the lawsuit, we are already working on the legal structure of the third lawsuit regarding selective marital surname. As for same-sex marriage, the Sapporo case has been moved to the High Court for appeal, and rulings will continue to be made at the district court level in other areas. Ultimately, we expect the Supreme Court to make a final decision around 2023 or 24. However, it will take several years to reach the Supreme Court. Only the Diet or the government can solve this problem that we are facing now. The United Nations has already recommended to the Japanese government 3 times to correct the current law that exclude couples who wish to keep separate names from marriage. In addition, public opinion polls have shown that more than 70% is in favor of selective marital surname system. As to same-sex marriage, the Sapporo District Court has already ruled that the current law is in violation of the Constitution. And Article 99 of the Constitution stipulates that Diet members and ministers are obligated to respect the Constitution. In order to fulfill this obligation, it is necessary to promptly amend the law. And public opinion shows that more than 80% is in favor of legalizing same-sex marriage. Lastly, Kyoko Tsukamoto, one of the plaintiffs in the first selective marital surname lawsuit, passed away in 2019. Until just before her death, she actively spoke out for an era in which anyone can freely choose their names regardless of gender. Ikuo Sato, one of the plaintiffs in the same-sex marriage lawsuit, died of a brain hemorrhage in this January. Before his death, he said in the court, "In my last moments, I want to hold the hands of my partner who legally became my spouse and say, "Thank you, I was happy." Allowing same-sex marriage means that future generations will not have to feel the same negative feeling about themselves that I had when I was young. Neither selective marital surname nor same-sex marriage is an issue that will suffice if realized someday. At this very moment, there are people who are struggling to live with the fact that they are not recognized as legal families. We strongly urge the government to take immediate action. Thank you very much for your attention.
Thank you, Terahara-san, to you also, and for reminding us that even the traditional family definition is changing in 21st century. And we also salute the names you mentioned, Kyoko Tsukumoto and Ikuo Sato, who fought hard for these changes, the same surname and same-sex marriage. Now, I just want to open a little bit of conversation here by making maybe a comment and asking a question following that. And then I'd be very happy to hear from the floor, and also we have a question online waiting. When I was researching this issue, and by the way, you are more than welcome to answer in Japanese. We have our lovely interpreter, Nakamura-san. When I was researching, I was surprised to learn that, in fact, Japan's constitution, which was written after World War II, includes one of the most, I would say, liberal equal rights clauses. And that is thanks to a 22-year-old woman named Beate Shirota Gordon, an American woman, who wrote equal rights into this constitution. I believe they do not even exist in the US Constitution. They have been trying to pass the legislation for equal rights amendment. So in one way, Japan is one of the most developed countries when it comes to the rights in the Constitution. However, at the same time, first of all, there are some underlying values, traditional values, which stop this family system, being changed. I just want to ask, what are these underlying values that is stopping Japan to change? And also, if I may ask, especially Terahara-san, I know that when Japan's Supreme Court in 2015, as you suggested, ruled against a lawsuit seeking to have the Article 750 declared unconstitutional, I believe of the 15 justices, there were 3 women, and they were the only ones opposing this, saying, some women may voluntarily choose to adopt their husband's surnames, but there are other factors. For example, their socioeconomic status is weak in comparison to men. They are in a vulnerable position in the household. So that leaves them with little choice but to accept this name change. So this seems that there is a more fundamental problem here than just changing the law. How can Japan solve this? So if Nakamura-san, would you like to summarize this long comment and question? Thank you.
私の方からではコメントとそれから質問、取っかかりということでさせていただきたいと思います。まず一つ目の質問なんですけれども、日本国憲法というのは第二次世界大戦の終わった後に作られたもので、この日本国憲法の中にはその平等という条文が含まれています。で、これはその当時22歳だったアメリカの女性 ベアテ・シロタ・ゴートーさんという女性がこのイクオリティ、平等という概念を憲法に盛り込むべきであるということで入ったと聞いております。でこれは非常にその先進的なことで、アメリカは1920年以来ずっとその憲法にアメリカの憲法にも平等という文言は入っていません。でアメリカでもずっと1920年以来こういったその文言を入れようとしてるんですが、まだ可決できない状況です。という意味で、その一つの意味では日本の憲法は非常にその最も先進的な内容であるということがあるわけです。ただその一方でそういったその憲法があるにもかかわらず、その底流に流れている、その下に流れているその伝統的な価値観というものがどうしても日本にはあって、それによってその家というその今まであったそのシステムはなかなか変えられないようになっていると、そこに流れている価値観というのはどんなものなんでしょうかというのが最初の質問です。で2つ目の質問はそれに関わるので、寺原さんに伺えればと思うんですけれども、先ほどお話がありましたその最高裁での2015年の判決、これ同性の方ですね、の方の結婚ですけれども、この中で15人の判事がいて、そのうち3名が女性だと、そのうちの1人だけがその反対意見を述べていると。でその女性は、日本の女性はその、名前を書いているけれども、それはその好んでやったわけでは必ずしもなく、例えば経済的な理由であるとか、家族における弱い立場であるとか、その選択肢があまりない中で、そういったその、名前を変えるということを強いられている。これはただ単に法律を改正するということに限らず、非常に根本的な問題ではないかと思います。でこれをどのように解決するということができるのでしょうかというご質問です。
はい、ありがとうございます。最初の質問をお答えすると、日本は1898年から夫婦同姓、いわゆる強制的な夫婦同姓が始まったんですけれども、そこが同時に家制度という日本独自の、制度が始まりました。そこには、トップに、リーダーに男性がいて、妻子は同じ名字であり、女性には財産権がない、離婚を言い出す権利もない、あとは親権も片側にない、特に髪の毛を切る時にもそういう戸主という一番リーダーの許可が必要というような制度がかつてありました。
Can we? Yes, Nakamura-san.
Let me answer to your first question. In Japan, it was back in 1819 when the compulsory same surname system started here in Japan. At the same time, ie, or family system, started here in Japan. And that was a kind of very special system in Japan. For example, the father is the leader of the family, and they have everything and every right. And their wife and children need to have the same surname as their husband. And wife didn't have any property right. They cannot say they want to divorce from her husband, or the women cannot have any parent rights or authority either. Even when the women or wives want to cut their hair, they need to get the permission from their husband.
私が国会議員のいわゆる反対の議員さんともお話をする中で非常に強く感じるのは、この家制度の考えをまだ今の時代において74年経ってもまだ、彼らの中にあるということが一番大きな問題だと思っています。
So when I'm talking with the opposition lawmakers in the Diet, what I feel really strongly is still now, even after 74 years, they still have the very strong mindset for this ie, or family system, and that is really strong remaining in their mind.
私は日本国憲法実は好きです。11条から14条、そして先ほどご指摘のあった24条、素晴らしい内容が書かれています。
Personally, I like Japanese Constitution. I like the Article 11 through 14 and the Article 24 that you mentioned earlier. They stipulate something wonderful thing.
根底にやっぱり個人の尊重、そして、平等原則、両性の合意のみによって結婚が成り立つという平等の原則が流れているんですけれども、そこを本当に実現をするためには、まず私は最低限この自分の名前をキープする権利というのは必ず必要だと、最低限の、最初のスタートだというふうに思っています。
So underlying thought of the Constitution is the respect of the individual rights and also equality. Only the two, husband and wife agree to get married. That sort of wonderful thought is now in the Constitution. But in order to materialize or implement this kind of nice spirits, at least, at minimum, we need to have the right to keep our own original name, surname.
もちろんそれだけで不平等がなくなるわけではない。家制度の考えっていうのは明らかに差別的であったので法改正がされたわけなんですけれども、それは少し今を生きる私たちの意識を変える程度のやっぱり変化しかないかもしれませんけれども、そこすら実現できなかったら、こういった本当の平等、憲法が謳う本当の平等には近づけないと思いますし、もう一つは、タックスですね。例えば配偶者控除があるために女性が、社会進出をしたくてもあなたはしなくていいでしょというような足かせにもなっている面がありますから、私はやはりまず名前の権利、その次にやはり賃金の平等を求める、機会の平等を求めるのであれば、そのタックスの平等というところもぜひ叶えていってもらいたい。これは野田聖子さんもおっしゃっています。
So actually, changing this kind of changing the system to keep out your own surname or original surname does not necessarily change inequality at once, but and also the family system is discrimination. Therefore, the law has been changed. However, maybe we can change the mindset of the people, and in order for us to realize that, it is really important for us to realize the real spirit of the Constitution, the true equality of the people, and also I want to also point out the importance of tax. As you may know, here in Japan, because of the spouse deduction, the women, even if they want to work outside, they are refrained from working because of the benefits of the spousal deduction, and it might prevent the women from working outside. So first of all, we need to have the right to choose the surname by ourselves. At the same time, we need to change the system tax so that we can have the equality in the wage or salary.
はい、時に家制度イコール戸籍だと思っている人たちが選択的夫婦別姓は戸籍を壊し家族制度を壊すみたいなことをおっしゃる方が結構いるんですけれども、私たちは戸籍上で結婚をさせてほしいと。その戸籍の中に平等である限り私たちは問題がないと思っていますし、戸籍上でまずファミリーレジスターというのであれば形骸化をしない実態を伴った戸籍であってほしいというふうに思っています。ありがとうございます。
And some people think EA or family system is equal to family register, and they don't like. If they say they insist when they break the family register, they may break the family system as well. But I think it is really important to maintain or achieve the equality inside of the family register. And if that is the case, the family register should not be formalized, but we need to really have the true spirit of the family system. Thank you very much.
じゃあ2つ目の質問に対してお答えしたいと思います。最高裁の裁判官は日本では15人いるんですけども、で2015年の時の選択的夫婦別姓に関する最高裁判決ですと、15人中5人がこれは憲法違反だということをおっしゃって、その5人のうちの3人が女性で、その女性っていうのは、最高裁の中にもともと15人中3人しか女性がいなかったので、全ての女性がこれは問題だというふうに言ったというのが流れです。はい。
So let me answer to your second question. In 2015, there was the decision made by the Supreme Court about the selective marital surname case. And at that time, actually, there are 15 judges in Supreme Court, and out of 15, 5 judges said this is unconstitutional. And out of 5, 3 were women. And actually, there are only 3 women judges out of 15 Supreme Court judges. That means all the women judges say no.
はい。 でその憲法違反だとおっしゃった意見の中では、先ほどもお話ありましたように、これはその見かけ上は男女中立的な規定なんだけども、結果として女性の方が名前をほとんど変えていると、これはその根底にいろんな男女格差という深い問題があるということも、その判決のその個別意見の中で触れられています。
And those people just said this is unconstitutional, and their assertion is actually apparently the law itself is civil, and the law itself looks gender neutral. However, in reality, it is in most cases women who change their surname at the time of marriage, and that is because of the gender gap between the gender gap is underlying causes.
で根本的な問題を解決するためには、もちろんこの選択的夫婦別姓のことだけを解決するのは足りずに、例えば国会議員の中で女性の数を増やすとか、最高裁の裁判官の女性の数を増やすとか、賃金格差をなくすとか、いろんな分野での取り組みが必要ですけども、その中の一つとして、この問題もあるという位置づけかと思います。
So in order to overcome this problem, of course, the selective marital surname system is not the only solution. We need to do many things, including to increase the number of the women lawmakers in the Diet, or increase the number of female judges in Supreme Court. And also we need to think about the difference of the salary between men and women. But one of them is this case of the selective marital surname.
で今年の6月に出ました2回目の最高裁の決定では、15人中4人がこれは憲法違反だと、今の状況がということをおっしゃって、そのうちの1、2、3、1人が女性ですね。もともと女性が2人しかいなかったので、そのうちの1人が女性になっていますと。
As for the recent Supreme Court decision made in June 2021, this year, that is the second decision actually, there are 15 judges there, and 4 said it is unconstitutional. And out of 4, there was 1 woman judge. And actually, there are only 2 female judges out of 15 judges in Supreme Court for that case.
で今回の2回目の訴訟の方では、男女不平等ということとは別に、それとは置いておいても、結局その結婚するときに、氏を前の自分のもともとの名前名字を維持しようと思えば結婚できないし、結婚しようと思ったら名字を変えなきゃいけない、どちらかがということで、これはどっちも重要なことなのに二者択一になっている。でそれもおかしいよねというふうなことがその反対の憲法違反だという意見の中で述べられています。
In this second Supreme Court decision, in addition to the gender inequality, they also said actually there are kind of, two options are left to the people. If you want to keep their own original surname, they cannot get married. And if they want to get married, one of the two in the couple need to change the surname. So it's a kind of strange situation. Therefore, this is the unconstitutional. That's one of the opinions given by the judges.
で最高裁が2回にわたって国会にボールを投げて、自らの役割をきちんと果たさなかったということはとても残念なんですけども、この憲法訴訟の、一般的な、流れとして、今は少数であるその憲法違反だっていう意見が時の流れによってそれが多数意見になって、全体として憲法違反だという判断になるということはありますし、我々もそれを求めて、次の第三次訴訟を行うべく準備をしているというのが現状です。
It is really unfortunate for 2 cases, for 2 decisions made by Supreme Court said this is a matter to be discussed by the Diet, and Supreme Court didn't exercise their, responsibilities. It was really unfortunate. However, even though at this moment the the opinion of unconstitutionality is a kind of dissenting opinion, minority opinion, I hope the people will be getting more and more aware to make this opinion majority rather than dissenting opinion. I think that's possible. So with that hope in our mind, we are now trying to work on the 3rd lawsuit.
Thank you. Can I ask if any comments or any questions from the floor? Haruko, do you have anything? to comment? Haruka Watanabe is one of our esteemed women's rights proponents. So anytime you're ready, if you want to comment on what we've been discussing. But I have a question meanwhile online. It comes from Pio Di Milio, who is representing Italy's Sky TG24. His question: in Italy, before the family law was duly amended back in 1985, couples sued the government in order to get their right recognized. Many courts upheld their wishes, and the Supreme Court eventually ruled the one name only unconstitutional. Is there any chance this could happen in Japan? Are there currently couples that are seeking their right through the courts that you know, without naming the names perhaps, if you can tell us a little bit about the human examples of this. 中村さん。
はい、一つオンラインで質問いただいておりますイタリアのスカイ TG24 というところからピオ・デミリオさんからご質問いただいております。イタリアでは1985年にファミリーロー、家族法ですかが改正される前に、夫婦から訴えがありまして、それでさまざまなその裁判が行われました。その中で最高裁での判決が出まして、その法律の中で一つの名前のみが優先されるのはおかしいというふうになったわけですけれども、このような動きという、実際にその裁判の中で一番最後のところがちょっと分からなかったんですけれども、裁判の中で実際にそのようなその人権についてとつなげて話し合われるというようなことは、人権とつなげてこの話題が議論されるということは日本ではないのでしょうかというご質問だと思うんですけれども、違ってたらごめんなさい。
はい、もちろん裁判は人権侵害だということで1回目の裁判も2回目の裁判もやってます。具体的にはこれは婚姻の自由の侵害だということ、みんな同じように婚姻をする権利、人権があるのに、同姓同じ名前にすることができる人だけが結婚できて、自分たちのそれぞれの名前を維持したいと思う人は結婚できないというのは婚姻の自由という権利の侵害だということを言っています。それが一つ。それからもう一つは平等権の侵害ということを言っています。同姓同じ名前にすることを希望するカップルだけが結婚できて、それに伴うさまざまな法的効果とか社会的承認を得ることができるということは、別姓を希望するカップルに対する差別的な取り扱いだということで、いずれにしてもその、人権侵害だということは裁判で主張しているところです。
Yes, here in Japan, we are asserting the violation or infringement of human rights in both cases of the Supreme Court, the first one and second one. And first one is the infringement or violation of the freedom of marriage. Everyone cannot get married in the equal basis. Only the couples who can accept the same surname can get married, and people who prefer to keep their original name cannot get married, and that is an infringement or violation of the freedom of marriage. Second one is the violation of the equality, and can I say only the people who accept to change one of them surname can enjoy the legal benefits or social approval, and it is the people who prefer to keep their original name cannot get those benefits socially or legally. That is the discrimination. So yes, here in Japan we do have a lot of discussion about the human rights in the courts.
Do you want to add?
これ最近各国に住んでいる日本人ジャーナリストの人たちが、自分が住んでいる国の結婚の法律がどうなってきた、そして名字の 法律がどう変わってきたかというのを、本を作ってくださったんですね。で一部がもうウェブサイトに朝日新聞の論座というウェブサイトで連載になっているんですけれども、どの国も割と同じ問題を抱えていたということが私にとって非常にフレッシュな話でした。はい、そこまで。
So quite recently, the Japanese journalists living in different countries worked together to investigate their country's, can I say, history of the marriage law or the surname laws, and they published a book on the website. Recently, on the Asahi newspaper, the, can I say, installment of the articles are now being published, and I learned from their researches that every country they have very similar problems, and that was really, can I say, fresh notification for me.
例えばアメリカにはカバチャーという法律があったというふうに聞いています。
カバチャ。
カバチャ。I don't know how to pronounce.
For example, in the United States, there was a law called kavacha in the United States.
それにはやはり同じ名字にするという規定があったり、あとは州によってなんですけれども、夫の名字に変えない既婚女性は投票権がなかったりしたということを書かれていました。
And according to that kavacha, they are forced to use the same surname, or depending on some states, if the woman, the wife, do not agree to change their name to the husband's surname, they lose their voting right.
国連がやはり1970年代から各国に改善勧告をしていって、で一つ一つみんなどの国も一歩一歩努力をしてジェンダー平等に向かっていったんだということが、その連載で一端を見ることができました。
And I learned from their article that United Nations made some recommendation for improvement from 1970s, and each country people make efforts step by step to win the gender equality, and that's what I learned from that article.
私は日本はもともと夫婦別姓の国でした。そして西欧化によって夫婦同姓の規定が、家制度とともに始まったというのが歴史的な事実なんですけれども、侍の時代ですね、武家や、豪族の女性たちは出自生まれの名前を誇りを持って名乗ったということが分かっていますので、そのように、自分たちの名前をキープしてで、自分のルーツを大事にしたいという人たちが、一部でももしいるのであれば日本も導入すべきですし、30年もこのままで、最後の一国になっているのは非常に恥ずべきことだと思っているので改善が必要だと考えています。
Actually, historically, Japan used different Japanese family, husband and wife use different surnames. Actually, after that, because of the westernization in Meiji period, the Meiji government introduced the system of the compulsory same surname system together with the Ie family system. So back in the history, samurai family and their wives identify themselves proudly by using their own original family name, surname. So I think want to keep their surname or our surname, original surname, is a kind of expression to take care of the root or value the root of the family. So if there are some people who really want to keep their original surname, I think we need to do something, and it is really a shameful thing that Japan is the last country in the world doesn't change things for 30 years.
Thank you. Haruka-san. どうぞ。
Ilgan, thank you very much. Yeah, Haruko Watanabe, HKW. I have the most or the least minority opinion. If the family leave all the estates to their daughters instead of their sons, then the man would like to marry her instead of girl married to him. ですね、財産権その他をお嬢さんに娘さんに移せば、結婚するときは娘さんは旦那さんの名前にならなくって旦那さんになる人が養子になるんじゃないですか。 マイノリティの意見ですが、そういうアプローチもあるんじゃないですか。どうでしょう。
よくとても極端な意見だというふうには思いますけれども、財産権、相続は今も別姓であっても、相続ができますし、同じ名字じゃなければ相続が発生しないとすれば、既婚女性はね、実の親から、財産を受け継ぐことはできない、そんなことにはなっていないので、私これはそこまでじゃあお願いします。
I think this is really extreme opinion, but I understand your opinion. And here in Japan, when it comes to the property right or inheritance, even using the different or separate surname, women do have the inheritance rights, so they can inherit things.
私自身は望まない改正をしましたけれども、それを自分の配偶者にじゃあ押し付けてそれでおしまいというふうには思わないので、お互いに変えたければ変える、そして変えないでも置けるというような、チョイスが男女ともにないと、これはやはり禍根が残る、どのみち人権侵害が起こるというふうに思っているので、女性だけがじゃあそれで救われる必要はないと思います。両方に同じ権利が必要です。
So, I changed my surname without against my will, but I didn't like to force my spouse to change his surname when he get married with me. So I think we need to have neutral right to change name if they want to and keep their name if they want to. So both men and women need to enjoy their own, preferences. Otherwise, people may think some problem remains in the family. So we don't like to infringe or violate the human rights, and we don't like only women can enjoy the good, their own surname preferences.
私京都から来てるんですが、京都というのは財産とかいろんなものをお嬢さん長女に移すんですよね。それでおじいさんが結婚したかったら養子に来い、そうじゃなかったら結婚させないっていうケースが随分あるんですよ。パーセンテージに言うと分かりませんが、old family in Kyoto, the men married to their daughter instead of daughter married to them. Yes. ですからですね、あまりリーガルのこと固く言わないで、非常に魅力的なお嬢さんでしっかりした基盤があれば、男性の方が名前変えて、名字変えてくれるんじゃないですか。ちょっとしたコメントですが。
This is a small comment. So if the daughter is really attractive and do have some money, maybe men willing to change their surname.
Actually, a very good point, Mukoshi-san. I was just going to ask about the system of mukoyoshi, adopting of the adult males, in which case men are more than happy to change their last names. So it seems like a contradiction to us foreigners. But do you have anything, please, very shortly, because we have 4 minutes?
そうですね。今のコメントに関してなんですけど、多分そういうことができて、それがお互いにハッピーな関係の場合はいいと思うんですけど、ほとんどの場合には多分そういうことではないと思うので、いろんな場合でもそれぞれのカップルが同じ名字にするかどっちの名字にするかっていうことを、選べるって選択肢がみんなに同じようにあるっていうことが一番いいのかなと思ってます。
So about Watanabe-san's comments, I think if both spouses are happy, men and women happy, that will be okay. But in many cases, one of them is happy, but the other might not be happy. So I think various options are available to the couple, and couple can freely choose whatever they like. That will be the appropriate case.
Okay, thank you, Watanabe-san, for your comment and for your answers. We have another question online from another journalist, Dennis Normel. He's asking, I think one of our guests said 70% of the public are in favor of allowing married individuals to decide for themselves what name to use. How can the LDP members of the Diet so easily ignore the preferences of the people of Japan? And to which, if I may add, Kishida-san's vision saying, I will listen to the public. What does it take for Japan to hold a referendum, for example, on the surname change or any other issue? Thank
もう
you.
一つオンラインでご質問いただいておりますデニス・ノーメルさんという方なんですけれども、先ほどの話の中で世論調査ですか、意識調査で7割の方々が自分で名字を選ぶ権利を持つということに対してやぶさかではない賛成であるということをおっしゃってたと思います。それだけ7割の方がそれに賛成しているにもかかわらず、なぜ自民党の方々はいとも簡単にそういった人々の意見を無視することができるんでしょうか。また岸田さんは人々の声に耳を傾けるというふうに言ってるわけですから、そういった中で例えば、国民投票といったような手は取れないんでしょう、打てないんでしょうか。
ちょっと国民投票についてだけ私の方からご説明しますけれども、日本ですと国民投票っていう制度が憲法を改正するとき、国政についてはだけしか取れないので、今回は憲法でこの選択的夫婦別姓をすることが禁じられているわけではなくて、法律を変えればいいだけなんですね。なので憲法を変えるという場面ではないので、国民投票というものは使えないということになります。
As for the referendum, actually here in Japan, the referendum is conducted only when we need to change the constitution, Japanese constitution. And for this particular case of the different surname adoption system, it is not constitution but the law which prohibit the couples to use the separate surnames. So in this case, the referendum is not relevant.
もう一つは日本の選挙、政界の成り立ちに近い話だと思うんですけれども、宗教が大きく関係しています。例えば日本会議、神道政治連盟であったり、統一教会であったり、そういう宗教票というものが今の LDP を自民党を支えている部分が非常に多く、そして彼らは家父長制を国民に続けさせたいという希望があるので、もし議員本人がいやいいじゃないか名前が選べてもというふうに思ったとしても、自分を支えている地盤がやはり宗教票で支えられている人にとっては、それに対して反対意見を述べづらいという状況があります。
So another thing we need to consider is the constitution of the Japanese political world. And in other words, it's a kind of religion groups voting power, actually. There are Shinto something association. And also 統一教会. So there are quite a few religion relevant groups, and many of those religion groups support LGBTP, and their way of thinking is they want to support patriarchy system, and they want to maintain the system in Japan, or a system in Japan. So even if the one person, the lawmaker think it's okay to change the law to adopt the selective marital surname system, but if he or she is supported by those regional groups, they cannot say yes.
Okay, so you think that's the problem, and that's why LDP members are so easily ignoring outright preferences.
安倍さんが一番日本会議の影響を受けた人でしたというのが今は、この長期政権の中で非常に大きな問題だったのというふうに私は思っています。一方で自民党の中にも非常に人権意識が高く、これを、きちんともう法改正しようというグループがあるわけですよね。で岸田さんはそこの呼びかけ人のお一人でもあったんですけれども、その周りの人たちも非常に私たちの話をよく聞いて何とかしてあげようということで頑張ってくれているので、自民党全体がそういう話でもないというのは理解していただけたらと思います。
And actually, I talked about LDP, and actually, it was former Prime Minister Abe who did have that kind of reference or supported by the original group, and that was one of the major problems that he ran the long-term administration in Japan. But on the contrary, even also in LDP, there are some people who are being highly aware of the human rights and willing to change or amend the law. So they did have a kind of group to support the selective adoption of the surname, and Mr. Kishida is one of the members to organize the group, and I think, and also his surrounding people are trying to listen to our voices. So I would like you to understand, not all the members of LPD do not listen to us at all.
Well, thank you very much. Thank you so much for coming here today, Naho and Makiko Terahara. And thank you for the comments from the floor. It seems Japanese women still have a long way before their rights are fully restricted, but the government is listening, hopefully, and show that it's serious about creating a society that is inclusive and equitable, as is stated in Japanese constitution. Thank you so much, Nakamura-san, also for your interpretation. I declare the meeting closed. Okay.
Thank you very much.